All right, welcome everyone to Understanding the Basics of the Perishable Agricultural Commodities Act. My name is Audrey Thompson, and I'm a staff attorney here with the Penn State Center for Agricultural and Shale Law, and I also serve as the program director for the Understanding Agricultural Law series. Today's webinar is part of the Center's Understanding Agricultural Law series, which is a course designed to provide subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent agricultural or rural clients, but who may not necessarily specialize in agricultural law. Next slide, please. This series is wholly sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center, established through the 2019 Pennsylvania Farm Bill. The Ag Business Development Center aims to enhance the long-term vitality of Pennsylvania farms by supporting farm transitions, both from generation to generation and from conventional to organic farming, supporting beginning farmers, providing risk management education, and providing financial assistance through low-interest loans and grants. Next slide, please. As you can see, we've covered numerous topics so far, including ag labor, land use regulation, crop insurance, conservation programs, ag finance, Pennsylvania's Clean and Green program, and many, many, many more. Materials and recordings from all of these webinars can be found on our Understanding Agricultural Law landing page on our website at aglaw.psu.edu. Next slide, please. Upcoming topics in our Understanding the Basics of Ag Law series include food labeling, clean and green separations and split-offs, which is going to focus on leasing, subdividing, or selling enrolled land. That's going to be great. Brook Duer is going to talk about that. We've also got organic production and producer protections for buyer defaults. Those are all on Fridays. They're all at noon, and registration is up and available for all of them on our events page on our website. And I'll also mention a couple other programs that we have coming up. We've got our Dairy Quarterly webinar series in February and April. So we're going to do an overview of the Pennsylvania Milk Marketing Law beyond the overorder premium. There's much more to that law than just that overorder premium. We'll also talk about an overview of U.S. state milk pricing systems in April. And then in March, we're going to partner again with the Pennsylvania Agricultural Ombudsman Program to offer another acre presentation. This will be in person. And this is going to focus on agriculture, local regulations, and nutrient management. And that will include Robert Willig, the Senior Deputy Attorney General for the Pennsylvania Office of Attorney General, and then Robert Minen, the Assistant Professor of Research with Penn State Extension, and our own Senior Staff Attorney, Brook Duer. And as I said, that'll be in person at the U.S. Hotel Tavern in Hollidaysburg. There's more information about all of those programs on our website for each one, so check that out. All right, I will now turn this webinar over to Brook Duer, the Senior Staff Attorney. Brook joined the Center for Agricultural and Shale Law in 2019. Prior to joining the center, Brook served as Chief Counsel to Pennsylvania's Department of Agriculture, and before his tenure at PDA, he practiced law in Lancaster County. I apologize, I'm from Missouri. Lancaster County for 18 years. Brook, the screen is yours.
Okay, thank you very much, Audrey. Good, thanks for letting me know that too. Okay, I turned my video on here just to say hi to everybody, but I am going to turn it off because I've been having some issues with my bandwidth, and I'm just going to make sure that I don't encounter any. So I'm going to stop the video here, not trying to be rude about it, but I know you love to see my bald head here and the sun shining off of it. Okay, there we go. That will hopefully prevent any future problems. Okay, so again, we're here to talk about the PACA, the Perishable Agricultural Commodities Act, which is a little obscure, but there are those out there, of course, who know all about it if you're in the fresh fruit and vegetable production business or some sort of ancillary business. And it has lots of little nooks and crannies. We're just going to do a very general overview here. And sorry, the slide that I have up here is not my title slide, but it was the next in the chain. And speaking of chains, I thought, why don't we try to put this, the PACA statute, the Perishable Agricultural Commodities Act statute, in a little bit of context around this concept of supply chain. And so, everything is so supply chain oriented, and that's such a buzzword these days in terms of how to understand our food system and where breakdowns occur, let's say, or where other issues come to the forefront that maybe need to be addressed. And I think it's since COVID, we've all kind of begun to look at things a little bit differently sometimes in terms of what can happen or what does happen and where intervention might be needed to make sure that supply chains don't break down. And also, you sort of then can, if you start looking at at agriculture as this series of supply chains, then you can sort of more maybe intelligently analyze, where does the government come in, to regulate some part of the supply chain somewhere along the line, because that's needed to maybe keep it flowing, or also needed to make sure that those at the very outset of the supply chain, i.e. the ag producer, the farmer, is protected in the ways that the government feels are appropriate for protecting farmers from the fact that, and again, this is all sort of theoretical, but it's good to put it in context, which is that, we're talking, agriculture is a business made up of, literally millions, hundreds of thousands for sure, of individual producers who all just happen to be in the same business or in related businesses of producing food in one way or another, or feed or something else, but we're here to talk about food. And all of those individual farmers don't necessarily always have the wherewithal, the clout, the business structures, etc., to it's not compete, but to essentially be in the business with some of the mega conglomerates that they are supplying to. And so there is a little bit of a perceived and actual imbalance of power, shall we say, at the particular spot in the supply chain where the farmer is essentially selling, distributing, etc., its product to the next person on the supply chain, a buyer. And so when you talk about a fruit and vegetable production, which is the subject of the PACA law, then you're talking about wholesalers, you're talking about large processors, such as, like, for in our area, Hanover Foods, or somebody else, all of the large buyers of fruits and vegetables. And again, sometimes you have a wholesaler or a middleman in there. Sometimes you're selling directly to some, very, very large corporation. So, going all the way back to the 1930s, really, and then PACA was in fact enacted in 1930. So it fits exactly with sort of the same timeline and the same story that we tell with regard to government regulation in agriculture that is to protect farmers and producers from the imbalance of power that exists. That pretty much starts with the Depression and the government realization that that imbalance of power may need to have some provisions made to balance it out, maybe. And so PACA is another sort of tool in that arsenal. And it happens at this very outset of the fruit and vegetable supply chain to try to sort of even out the respective bargaining power between the parties to some degree, and there are other purposes. But in any event, and if you look at it like, okay, when does the government get involved in regulating these little transactions that together make up this big, huge supply chain? And you can also, sort of helpful to look at it as this is just a series of legal arrangements that are linked together into this big supply chain. So we're talking about that very beginning link in the fruit and vegetable supply chain, and okay, does the government, second bullet point on this slide, does the government have an interest in regulating these contracts? Well, we've sort of talked about that already, that, they are, these little individual legal arrangements, these little links, they're each sort of a separate contract with its own attributes in terms of the negotiating positions of the parties, et cetera, and this level of sophistication of the parties. And we all kind of, if we're in this industry at all, or you rub up against it, it again all comes back to the fact that, unless you're operating as a cooperative, but even when you are, meaning a group of farmers trying to maximize their bargaining position by selling together as a cooperative, or a lot of individual fruit and vegetable producers, the government long ago recognized that it had an interest in that being involved in that transaction to sort of level the playing field, and continues to do that. So the question always comes up when the government's going to get involved in one of these links in the supply chain is, how much should be regulated? And that is that's where we get to the issue of animal production, agriculture, and then row crops and specialty crop production. They have different attributes, so they get regulated differently at this outset, this beginning link in the supply chain, and the individual commodities involved many times dictate or provide some degree of answers to that question. And the third bullet point here, which is which or how much do you regulate at a particular spot in the supply chain to keep it going, and the live animal or transacting a little business transaction to transfer a live animal is one thing. Transacting business with regard to pallets of, let's say green peppers or carrots or, cabbage, that's sort of another thing that has its own attributes. Now, there are two main statutes that are federal laws that have become the standard bearers and the main focus of the government. And this is again in the federal government level, federal government involvement in the first link in those chains. The Packers and Stockyards Act, and I'm doing this sort of by contrast, is the livestock and poultry version of the government's regulation of that first link in the supply chain for those particular commodities. The Perishable Agricultural Commodities Act, PACA, which we're here to talk about, is the equivalent in the fruit and vegetable area. And of course, other commodity fields have their own sometimes that apply, but these are really the two biggies that come into play with regard to regulating that very first link in the supply chain. Packers and Stockyards Act for livestock and poultry, and the Perishable Agricultural Commodities Act for fruit and vegetables. And again, I got on this slide again what we've already said, which is these are designed to address the disparity in bargaining power and the disparity in information between the parties in this little transaction at the beginning of the supply chain. Not so little, I didn't mean that in a bad way. There is many times, especially in the livestock field, the government has become involved in leveling the disparity over information in the livestock and poultry area. Particularly, one of the most recent things that occurred was an entire new set of disclosure obligations between poultry growers and other types of contract growers who are growing out livestock that actually belong to someone else. And then ultimately they, are delivered from the farm to the contract, or the animal owners, the contracting party, sometimes called the integrator, to their facility. And so information disparity is or the disparity in access to information is one of the main areas that livestock producers, need to know what else is going on in this business. What is this? What is the, auction price for, cattle on the hoof, in Texas or in Pennsylvania or in Iowa or whatever it may be. All this market information and required disclosures is one of the ways that the information disparity issue is addressed in that particular field. Now, And one of the other things that comes into play is, of course, the increase in, perishability of the commodity itself at various stages may lead to more intense government regulation at that stage. And again, as I mentioned, when we have the increasing growth of vertical integration, that has brought a lot of maybe just renewed understanding of the disparity between the party that's actually producing the animal or the commodity, and the person that is ultimately going to pay them for it. One of the things that contract growing for fruits and vegetables isn't as hot a topic at this point in time as it may have been at one time, where it's not as widely used, and it's certainly not as widely used as it is in the livestock and poultry field. But there are still areas where there is contract production of fruit and vegetables. So the Perishable Agricultural Commodities Act is what we're here to talk about, otherwise known as PACA. It was enacted in 1930. And I have here on the slide here, show you some of the, those are anything that's blue with underline is a link. So you got links to the statutory authority in 7 USC and the 7 CFR Part 46, which is where the regs for PACA exist. And again, this is the analogous statute to the Packers and Stockyards Act, and the Packers and Stockyards Act has multiple tentacles. It's much more complex than the Perishable Agricultural Commodities Act, and the way that those two acts are different, and maybe we will do one on the Packers and Stockyards Act someday. Keep in mind, this is a general practitioners type of webinar program. In other words, at a very entry-level basic understanding. And it's kind of rare that as a general practitioner, attorneys would be getting involved with Packers and Stockyards Act issues, but not necessarily unheard of. Or you might be representing a buyer in the chain in the livestock and poultry field. In any event, all of these programs are administered by USDA's Ag Marketing Service. And Ag Marketing Service it's one of those parts of USDA where they have a mixture of missions. Some of the Ag Marketing Service is pure support for the regulated industry in one form or another. In other words, to help marketing efforts and to move products, whatever they may be, and whoever may be the party who's looking to move that product and to sell that product. We also have the regulator function. So when I was at the PDA, we used to say you got your cheerleader hat and you have your regulator hat. And I don't mean cheerleader in a bad way. It's just a term that we would use to describe those non-regulatory functions sometimes that government gets into, that also provides assistance to players in the supply chain, just like the regulatory functions supply assistance, but in a different way. They provide assistance to somebody in the supply chain by potentially regulating their and I don't want to use adversary in a bad context, but the other party in the transactions that this person may be getting involved in. So sometimes the cheerleader and the regulator hat kind of mix, and this is a little bit one of those areas, because this is so clearly a statute that is written to benefit and provide a service in some ways to producers, the first link in that supply chain. And I'm going to tell you a story that I when I was a young lawyer, in fact, right out of law school, I had an experience that was just up, it wasn't a crop or a commodity that would be covered by the PACA law, but it taught me all the reasons why the PACA law, needs to exist. And I was right out of law school. I come to Lancaster County. I'm working for the president judge there as his law clerk. And one of the jobs of the law clerks who work in the courthouse and the judges' chambers is, when there are compulsory arbitration panels, And for those of you who aren't lawyers who might be attending, that's essentially sort of a small claims court process for cases under $50,000. I think is now the federal or the PA rules civil procedure limit there, where you're not going to a jury trial first, you're going to a compulsory arbitration hearing first. That's a panel of 3 attorneys. So anyway, what would happen is there'd be compulsory arbitration hearings. They'd run over to the judge's chambers and say, some attorney called and said they couldn't show up. One of the arbitrators can't come. Come over here and sit as an arbitrator. So that would happen to be, pretty regularly. First time I ever got one of those calls to run over and serve as an arbitrator was I wasn't from Lancaster County. I wasn't even from really an ag background. This is 1989. And I walk into the room, and what the case turns out to be, first case I ever sat as an arbitrator, right out of law school. I think it was still the summertime. I just started. And there's an Amishman there, believe it or not, who is the plaintiff. And there is a tobacco buyer who is the defendant. And the Amish plaintiff, which is unusual enough right there, although I didn't realize how unusual that was, that in 1989, they were using the legal process as a plaintiff. And there are these giant piles of tobacco sitting on the table, and the entire room smelled like tobacco. And there's crumbs of it, like, on the ground because it's all dried. And, and it's, there's literally multiple bales of tobacco sitting there on the table in the hearing room. And that was odd enough, to see and to be, presented with, as it was. But then I hear the case unfold, and it's this big case all about the claimed wrongful rejection of the tobacco by a tobacco buyer who had a pre-existing production contract. And so it was all about, was this grade A or was this grade B? And those aren't the grade type names, but you get the idea. And what did this tobacco really fail to qualify for the requirements of the production contract? And so the buyer rejected it. And of course, the suspicion is they're just rejecting because they don't like the price that they locked in ahead of this growing season. Now that things have changed and prices are now set, with harvest having come in. Well, I'm quickly running back to grab a copy of the UCC because I'm right out of law school thinking, oh, this is all UCC stuff, which it very well can be. And so I'm pulling out the UCC, which is enacted in Pennsylvania, of course, and everywhere else. And the other 2 lawyers had been in private practice long enough that was like, I haven't seen the UCC in years. We haven't read this thing and used it since we were in law school. And so anyway, we tried to sort this whole thing out by applying the UCC to this claim of wrongful rejection. Well, while tobacco wouldn't be covered by the PACA Act, it was a very graphic example of exactly why PACA exists. And in some ways, it does supplement UCC principles. For those young lawyers who even remember what the UCC is and does and says. So anyway, that's my story that here I am all these years later, 30, whatever, 4 years later, and, still talking the same subject. All right. Perishable Ag Commodities Act. Here is some resources for you. We have a document, Understanding the Basics of Perishable Agricultural Commodities Act, and it's on our website, and here's the link to it right here. And then also, there's a real nice thing that Harrison Pittman, who is the director of the National Ag Law Center, wrote many years ago, Perishable Agricultural Commodities Act, simply titled, but it's very nice for a nice little introductory read. And I've pulled, many of the focus things for this out of there because it's a nice organization of the information. Also, here's another interesting resource that just came up recently in November of 2023. There's a podcast that's done by this Law Street Media, and it was just happened to be about essentially PACA issues. And that's pretty rare because this is a little obscure in the grand scheme of things. So here's a link to it: Fresh Produce Law, Contracts and Risks. And it was an interview with an attorney who specializes in this area of the law. So there's a link to it. And I also have, there's a LinkedIn link to it because sometimes, these websites may come and go, but hopefully the LinkedIn link will stick around. So there's a couple resources. Okay, now let's talk about the background. We've sort of laid a lot of groundwork here. It's all about the marketing of fruits and vegetables. They have certain attributes like minimal personal contact with the buyer. Sometimes, there is literally, it's all transacted, without any face-to-face meetings. Sometimes there are face-to-face meetings, whether it might be an auction sale or something. And there are many, fruit and vegetable auctions out there where wholesalers and retailer buyers, come to buy the product that may appear in the giant food store or the Weiss or wherever it may be. And you, of course, have this perishable product with a short shelf life, and some of it may have very special handling requirements. Some of it's much more susceptible to bruising easily. Some of it can be handled more roughly than others. So you have some issues there, and again, because it's this sort of situation where the party may have sold with no real contact with the buyer of any appreciable nature, and the product's gone as soon as it leaves their possession, the seller's possession. They have so little bargaining power at that point over what happens after that. Hence the case that I was telling you about with the wrongful rejection of the tobacco. That's the kind of thing that, that tobacco left this gentleman's hands, and all of a sudden, he hears that it's been rejected, and then it actually came back to him eventually. Because they did reject it. And so, there's a very disparate, bargaining power to the seller in these kinds of situations also. Now, auction settings may be a little different, but that's, that is a minority probably of what's being sold out there in fruits and vegetables. Auction is not the main percentage or the main share of what's being sold. Now, okay, purposes of the Act: prevent unfair and fraudulent conduct in the marketing of perishable ag commodities, facilitate the orderly flow of perishable agricultural commodities, interstate foreign commerce. Okay, just statutory language, but important. And tells you what the thought process here is. Now, there's three basic threshold requirements for PACA to apply. You have to the entity that is subject to subject to the Act needs to be one of the defined regulated entities, which we'll talk about. We'll have some slides on that. And then you have to have an actual perishable agricultural commodity. We'll have some slides on that. And then you have to be essentially injecting it into interstate or foreign commerce. So that's the three basic threshold requirements. First of all, regulated entities. Okay, who's regulated? Well, the sellers are not regulated, or I'll put it this way: a producer seller. In other words, if you're selling, if you're acting as a seller of something that you in fact produced, a commodity, then you're not regulated here. That's not what it's for. It's for regulating the other side. So it's dealers, what is termed commission merchants, and brokers. So what's a dealer? Anybody is engaged in the business of buying or selling. They can be selling wholesale. In other words, that's just distinguished between selling wholesale and selling as the producer, a producer seller. You're not regulated by PACA if you're not doing at least $230,000 of purchasing for resale, essentially. So that's the monetary threshold where PACA does not apply if, you're not a dealer under PACA if you're doing less than that amount of business. Commission merchants: any person engaged in the business of receiving in interstate commerce any perishable agricultural commodity for sale on commission or for and on behalf of another. In other words, this is a non-producer seller. This is somebody else who is selling and selling on behalf of somebody else, and then a broker, a person engaged in the business of negotiating sales and purchases on behalf of some vendor or purchaser. All right, so, and the idea being here that this net will capture everybody who's in this business, whether they take title to the commodity or not in the transaction. They may be simply acting on behalf of someone else who is the one who will take title or may have already taken title or whatever the case may be. So there's your three categories. And again, there's a lot more to these things, but this is just a general overview. Here's the definitions. Don't need to really go into a whole lot of except to just point out that a dealer, the last sentence on the first paragraph, that's where the producer seller is excluded from the concept of a dealer, because you could be in the business of selling wholesale and do more than 230,000, but if you produced it yourself, you're not covered, which is what that last sentence says. One of the exceptions states that a person who sells a perishable agricultural commodity of their own raising does not constitute a dealer. So that's where we sort of carve out the producer. Okay, and then there's various ins and outs of the definitions here, not particularly notable. Okay, now, or they may be, depending on what the case may be, but you get the gist, and that's all we're here to give you, and then you can go from there with the knowledge you gain here today. Okay, so what's a perishable agricultural commodity itself? Well, this is kind of a big one. The statutory definition, this is a nice little way to just boil it down. Fresh fruits and fresh vegetables of every kind and character. Now, we're going to look at another slide that'll get into that in more detail. Now, the regulatory definition provides much more specificity than this statutory definition, and here they are. On this slide, you see the statutory definition on the top, and of course, this is where the wording, fresh fruits and vegetables of every kind and character comes from. Now, the regulatory definition points out the important takeaway here to understand, which is, okay, it includes, they needed to be a little more clear and flesh it out somewhat. So fresh, and it's one of these definitions where perishable agricultural commodity is defined as fresh fruits and vegetables. So then you got to look at the fresh fruits and vegetables definition to really see what the definition is, what you're dealing with. And then, of course, by the way, you see the little lobbying effort. Somebody in the cherry business needed to have a revision here to say that cherries and brine were included in perishable agricultural commodities. Why? Because there are fresh fruits and vegetables. You need to sort of carve out from that potentially things that have been processed in some way, shape, or form between the farm and, when the sale occurred. So that's why I'm going backwards in the wrong direction. There we go. So that's why we have this more long-winded regulatory definition here. All forms, all produce in fresh form generally considered as perishable fruits and vegetables, whether or not packed in ice or held in common or cold storage. So, just refrigerating it is not processing it, but does not include those perishable fruits and vegetables which have been manufactured into articles of food of a different kind or character. Okay. And that's where the processing comes into play. The effects of the following operations shall not be considered as changing a commodity into a food of a different kind or character. And then there's this laundry list of all of these different sort of processing, minimal as some of them may be, type of activities, which they're saying these do not disqualify a product from being considered under the jurisdiction of the PACA law as fresh fruits and vegetables. And things like slicing, so the big issue in the apple industry a couple years ago was when McDonald's, I think it was, whoever it was who was starting to sell sliced apples in the kids' meals as an option instead of French fries. Then a lot of apple packers and people that were somewhere in the process of, okay, we grow the apples, but we could slice them and bag them because we do other types of packaging. And, and then were sliced apples processed, or were they still the raw agricultural commodity? And in this particular case, they remain, I believe would be the outcome here. They remain under the definition, even though they've been sliced. For many other agricultural law related definitions, slicing them up and putting them in a little bag like that means that, they are no longer a raw agricultural commodity. But you get the gist. I mean, waxing of apples or waxing of other vegetables and fruits is mentioned in here as something that does not disqualify something, even though you're applying the pretty significant or a coating anyway. So you get the gist. There's the line between processing, between aspects of processing or actions that could be called processing, and this is an attempt to try to parse those out a little bit and say, well, these minimal processing actions are not going to disqualify something from being considered under PACA's jurisdiction, despite this language about manufactured into articles of food. So, all right, now, interstate commerce. There's like a two-part definition to this, and this is kind of important little distinction to understand. The statutory definition is what's on the top. So again, we talked about the who's covered. You got to be a dealer, commission merchant, broker. We talked about what is covered, and now we talk about where is it covered in interstate commerce. Okay, so the statutory definition is commerce between any state or territory, or the District of Columbia and any place outside thereof. Okay, DC always has to have their own little thing. Or between points within the same state or territory, or the District of Columbia, blah, blah. Okay, so it's the term interstate or foreign commerce for the purpose of PACA means commerce between any state or territory or between points within the same state or territory. Okay, so that seems to be a general definition for interstate or foreign commerce that is very, very, very broad and can include what in some areas of agricultural law are considered to be intrastate commerce at times and not subject to interstate commerce rules. But here we have a sort of a broad take on it. But that definition is only keep in mind, talking about the general concept of commerce. What about these individual transactions within within this supply chain for an apple, let's say? And the second, these are both from the same section, the definition section of the statute, but they have two sort of provisions you got to read together. So it says the section 8, this little subsection B8 adds to this, which says a transaction in respect to any perishable agricultural commodity shall be considered interstate or foreign commerce if the commodity is part of that current of commerce, usual in the trade in that commodity, whereby this commodity is sent from one state with the expectation that it will end, that will end their transit. In other words, more or less saying that, what we might think of as intrastate would be included, with the exception they will end their transit after purchase in another. Oh, okay, sorry. That's for what we would traditionally think of as interstate, including in addition to cases within the above general description, all cases where sale is either for shipment to another state or for processing within the state and the shipment outside the state of the products resulting from such processing. But then, okay, so that does seem to be a more traditional. But then it says commodities normally in such current of commerce shall not be considered out of such commerce through resort being had to any means or device intended to remove transactions in respect thereto from the provisions of this chapter. So they're basically talking about, don't get cute with us and try to create some kind of a, some sort of a tricky little way that you're going to try to say that this is an interstate commerce because, you created a warehouse on the one side of the state line and you created a shell entity that transfers it to somebody else, at that warehouse, and it's really just you moving it across the state line. So they're looking out for those ways to try to get around it and say, oh, we're not covered by PACA because we're not in interstate commerce. So in any event, you just be aware that there is a little issue here. All right, now, Okay, so now we talked about the jurisdiction and the sort of the three prongs. Now let's talk about the basic provisions of what's in PACA. What's it do? Okay, basic provisions of PACA. First of all, there's the licensing provisions. Talk about that in a second. Next, there is this general statement of prohibition of unfair conduct. So that's in a lot of ways like the way the consumer protection laws are written, which is just like, well, doing any of these things in this, in this business will be considered to be unfair conduct, which is prohibited by the statute. And then what are the remedies and sanctions? What can be done about something, that is a prohibited act, either not being licensed or committing one of the acts of unfair conduct. So first of all, in the licensing area, basics are that, of course, all dealers, brokers, and commission merchants must obtain a PACA license from USDA Ag Marketing Services. And I believe that the license fee is something in the neighborhood of $1,000. I did see it. And in any event, I'm mostly assuming that the people that are attending this webinar are going to be a little more on the your clientele that you might be representing potentially, if your attorney would be much more on the seller side, the producer side, not necessarily. That's why I didn't memorize what the license fee is for for the dealers and brokers and commission merchants. But anyway, there's $1,000 penalty for being in this business doing those acts, plus of $250 per day. So, this stuff racks up fast. If you find out that somebody that you've been selling to, for example, and that's the classic way it comes up, you go look up somebody because maybe you've had some kind of little disagreement with them or something, and you find out that they're not even licensed under PACA to be buying your stuff. Or to be buying your clients' things. So, that's one of the most fundamental issues is, and you'd be shocked at how many people don't have a PACA license who have gotten into, the business of buying, ag commodities at wholesale, fruits and vegetables particularly. So, it's a really good thing to do, is, hey, check who you're dealing with, and make sure that these people have licenses to begin with. And you might be surprised. Okay. Little more on licensing. There's sort of several different ways that the licensing, requirement comes up. First of all, it's important to know that there is an ability for the secretary to refuse licenses, meaning that, USDA secretary, meaning that's AMS, Ag Marketing Service. And you can refuse to issue a PACA license to somebody who had previously had a PACA license revoked within 2 years, who has flagrantly, repeatedly engaged in unfair conduct or the prohibited acts, who has violated other sections of Title VII of the U.S. Code. Boy, that's a broad one. Those who were officers or partners of any previous enterprise that has been adjudicated or discharged as bankrupt within 3 years prior to the pending application. So bankruptcy could be a big black mark in the PACA world, because officers and partners of the business that went bankrupt can't just walk out there and, start a new, or get a new license and get right back into it. At least, the officers and partners, that is. And this is really, part of the whole concept is that if you've been a bad actor in this business, the USDA wants to be able to police not only your individual, but, might take your license and then you're completely out of the business. Nationally, that's a national license. So, so this is big time stuff to understand, which is licenses can be refused based upon your prior bad acts, so to speak, prior violations of the statute or other sections of Title VII. That's pretty broad. And so, and a license application can be, the last little number 5, can withhold the issuance pending an investigation of an applicant for prior violations. So it's, the idea was to make it so that buyers who have stiffed people, just cut right to the chase, buyers who have stiffed people before in the fruit and vegetable wholesale arena are going to be tracked, and they're going to be refused licenses. And bankruptcy isn't necessarily going to cure the problem, and then they just come back again. And potentially do the same things again. So there is, that is the way that this USDA licensing system can very much benefit sellers. And again, as I said, it's a national system. So, and then a dealer, broker, or merchant, can demonstrate to the secretary if they just failed to obtain a license, not if they have the bad history, but that it was not willful due to inadvertence. Now, how often that is, done, is not quite known to me, and it's probably very tough to to actually even look into that and do some research on that. But the bottom line is they have to sort of like they have to pay up for as long as they've been in the business, due to their willful, their non-willful inadvertence. So you just see that there is an exception there that for somebody without a license, but wouldn't be putting my eggs in that basket, if I was trying to be in this business. And then this is key. The third bullet point is that ongoing licenses can be suspended for a period not to exceed 90 days, except that if the violation is considered flagrant or repeated, I'm having trouble saying flagrant today, that then the license can be revoked. That's it's like the death penalty. And this is, pretty strong stuff for, in terms of immediate abilities to, if somebody's at a produce terminal, like, I don't know who in our attendees might be aware of the Philadelphia produce terminal, how big and huge this thing is, and how many people operate in there, and the quantities of produce that go through there. But, each one of those little, they're almost like little, it's like a mall basically. Everyone's got their little like a storage unit, except very large. And they got the big doors that come down, and everybody in there knows how bad this can be, and if you get you got your license revoked, even a suspension, everyone else sees it. So they see who's, what happened to so-and-so. And then that track record follows them, as you've seen in this slide. And there can be, in fact, a death penalty, an actual revocation of a license. And it can have, a period of years attached to it. And I do believe it can even be forever. Okay, now, unfair conduct. Again, this is like the consumer protection model where these things are generally stated. So I'm just going to go into, these are some of the basic words that are used, and it's all the same kind of things that you see in Unfair Trade Practices Act, for example, in Pennsylvania. Unfair, unreasonable, discriminatory, or deceptive practices, failing to comply with terms of contracts without reasonable cause. Discarding, dumping, or destroying product without reasonable cause, failing to make full payment, misrepresenting the characteristics of what you're selling, if you're selling a wholesale, for example, fraudulently altering federal inspection certificates, because there's a process, which we're not going to get into here today, about rejected product, and then having USDA inspection of it to sort of confirm, whether that's a proper rejection or not. And then, substituting other goods or goods that have been federally inspected. In other words, playing fast and loose with the actual produce itself, and trying to slip something else in as if it was what you're rejecting. And believe me, this is a sharp industry. I hate to say it that way, but, people need to be very awake and aware of who they're dealing with. And, there are sharp, actors in this business. It's not a business, particularly if you're, going to someplace like the Philadelphia produce terminal, you got to have your wits about you, and you got to be a sophisticated seller, if you're selling there. Now, couple of things. Oh, here we go. Here's another things that are listed in, the regulations as examples of unfair conduct, because they flesh this all out. And it's kind of the same, concepts. You get the idea. So, failure to pay, by the way, is, one of the unfair conduct, and it's probably one of the, most commonly used, let's just say, claims of unfair conduct under PACA. Okay, now the remedies. What can you do if any of these acts of unfair conduct, including failure to pay, happen to you or your client or whatever? So, several different ways this can go. Reparations is the word that is used in the act, and that is essentially a claim for damages, monetary damages, and you can do that either by a claim filed in the U.S. District Court, like a private right of action, or you can do that through USDA AMS. They basically act as the court, and they got they got dockets, and they have a little adjudicative wing that will essentially hear these, and so it can all be done like in-house, so to speak, just at USDA without going to the courts. So that's probably, the place where sellers, producer sellers want to be because it's a lot less, cumbersome and time consuming. I think the filing fee is a little bit, I think it's $500 to file with AMS for a reparations complaint. But that's the general way it goes, as opposed to in court, although some of these things do end up in court. There is dockets you can search on the USDA website, and you can look at them basically just like litigation dockets in some way. And then you can actually you look at the outcomes. You can see what the allegations have been, and there are written decisions and the whole bit. Now, there are also then licensed disciplinary proceedings, which is secondary to the reparations to the seller who has been wronged in some way, shape, or form. And that can take the form of, warning letters, or as we talked before, like fines or license suspensions or revocations. So that's a separate and parallel type of penalty, let's just say, for potentially engaging in, business practices that are considered unfair under PACA, including, again, failure to pay. Now, and we'll talk about failure to pay, because that's kind of the important one. That's what we'll spend the rest of our time talking about. Okay, now in the failure to pay area, there is this thing called the statutory trust that is created by virtue of the fact that you've conducted a transaction under the that has that falls under those three prongs of the PACA statute, and that create and again, like for example, in the livestock and poultry field, same thing. There's a statutory trust when you sell an animal and you don't get paid, or it's a statutory trust that exists even until you get paid, let's just say. So basic concept is the statutory trust provides the seller with sort of a priority to the proceeds of the sale. Now, it's a little difficult to capture that and enforce it, and we'll talk about that. And the sale proceeds are technically held in trust. And you know how it is when a statute uses the word in trust, that carries all this sort of common law baggage, mixed with sometimes statutory baggage, if it's a statutorily created trust of some kind like this. Now, one of the biggest areas that this comes into play is in bankruptcy. Now, let's talk about some of this so you get the concept. Okay, here's the statutory trust provisions. They were added in 1980. And this is really where the action, this is maybe one of the big, besides the licensure, sort of the discipline and that sort of thing, and the easier way for a seller to pursue their claim rather than just go hire a lawyer and file a collection action, is this statutory trust concept. Because here's what it does, and here's the statutory language up above, and we could go through that tooth and nail. But the bottom line is, it creates what is referred to as a floating trust. In other words, money received, or I should say, money promised to pay for fruits or vegetables purchased, but isn't paid, is fungible with all the other money that the buyer who stiffed the seller, possesses, so to speak. So realizing that the money is fungible, you don't have a trust on a specific dollar versus some other dollar that they have. It's sort of this floating trust concept, which here's how it kind of works. When a controversy arises as to which assets are part of the PACA trust, in other words, you might have several different entities doing business in close relationship as the buyer, and of course the buyer, the seller may not even know exactly how the business is set up until they get stiffed and they go to look into it. It's like a big, shell game or something. In any event, when a controversy arises as to which assets are part of the trust, the buyer who stiffed, the seller has the burden of establishing which assets, if any, are not subject to the PACA trust. And I should have probably added the word, which assets of theirs are not subject to the PACA trust, because the concept is this floating trust is it attaches to everything you own until you, Mr. Buyer, who stiffed somebody here, you got to prove somehow that this money is not freely fungible with the money that you're holding because you failed to pay them. The PACA beneficiary, meaning the seller, only has the burden of proving the amount of its claim and that a floating pool of assets exists into which the produce-related assets have been commingled. So, sorry, I went ahead there. So the concept is not, that you have to identify the exact, funds that they didn't pay you with and where they're located. That would be kind of absurd. It's this concept of, hey, I got a lien, so to speak, although it's not a lien, so let's not say that. I got this floating trust that applies to everything you own, unless you can prove to me that somehow some assets are not part of this portion of your business. So now, the other thing that comes into play, sort of the double whammy here, that is good for sellers and bad for buyers, is that, or bad for buyers, stiff people, is that the trust assets, to the extent that there is one of these statutory trusts is created by outstanding unpaid bills, that they are not part of the bankruptcy estate, because the buyer, theoretically, under the law, because of the trust, never had an equitable interest in those assets. In this case, they're going to be cash. It's sort of akin to a super priority in bankruptcy, but it's actually even better because these things aren't even part of the bankruptcy estate. Now, I think you still probably need to file a motion for relief from the stay to enforce. But the bottom line is you're basically outside of the trustee's powers. You're not lumped in there with all the unsecured creditors. That's why it's like a super priority. And you have a very significant leg up. So now, last slide here, Audrey, hang on. This is perhaps and maybe the most important slide that I'm going to show you here, which is, here's the caveat with this entire statutory trust concept. Okay, there's three little components. The agreed payment due date that whatever applies in this particular transaction paperwork, it must be 30 days max. In other words, it's got to be 30 days or less for the trust to be enforceable. So it's created for those who have good paperwork and don't let debts get stretched out. And so 30 days net is, is what you need to stick to, or less, in order to get the benefit of the statutory trust. Now, to preserve its trust interest, the buyer must provide written notice. Excuse me. You know what? I got a typo in here. Sorry. The seller must provide written notice to the buyer to preserve the trust's assets within 30 days of either the due date of the delinquent payment, which again had to be less than 30 days, or a failed payment instrument like a bounced check. So, so there is a written notice requirement to be telling the buyer that they stiffed you, and that you're giving them written notice. It's like a spoliation of evidence type letter where you say you must preserve my trust interest or my trust on your assets to the tune of $25,000 that you owe me, or whatever it may be. So you got to do this written notice, or, and here's the big or, you can do an alternative to the written notice if you get stiffed by having a blanket language on the invoices relating to the transaction. That is what is said in number 3 here. So you put this language on your invoices, and as long as there's no objection, and this has clearly become part of the written documentation of the agreement, the contract, then you don't have to do the written notice, because this is kind of like warning to the world up front, particularly warning to the buyer, that you as the seller, retain the wording, retain a trust claim over these commodities, all inventories of food or other products derived from these commodities, and any receivables or proceeds from the sale of these commodities until full payment is received. So you got to do, again, the key takeaways, your due date for payment needs to be 30 days or less. And you either have to give the written notice or you have to have this magic language on your invoices that become part of the written contract. Okay,
All right. Thank you so much, Brooke. That's awesome. I know this next slide, that is in that resources sheet. That's just a link to
right.
AMS's website.
And I was just going to say,
all kinds of stuff.
All our attendees should go to the website and look at this. What's available is very, very helpful. And there's just so much good stuff. So go ahead. Questions?
Yeah, it's great. So we've got a couple questions. If you could hang out with us and you want to hear some answers, that's great. If you need to log off because you got to get back to work, we totally understand. So the first one is, how long has the $230,000 threshold in the statute there been enforced? And do you know of any effort to raise that threshold in light of inflation?
That is a very good question. I did not look that up. If this person wants to email me or email us or somehow get in touch with us, I will look that up for you. I don't know the answer to that. There have been many amendments over the years, but I don't know when that was last increased.
Okay, so we just not sure. I'm gonna guess, probably not, but anyway, could you please discuss payment priorities and timing issues with seller, shipper, secured creditors, warehouse, etc.? I think
it's a little too vague to really answer. I tried to.
Right.
So let's go to the next one.
I think we kind of covered that.
Yeah, right. As best we can without more specificity. Right. Go ahead.
And then, okay, so we've got a comment. Could you give an overview or just, brief mention of the severe restrictions on licensing and employment in the industry that can be imposed on individuals who are deemed responsibly connected with companies that have had their PACA licenses revoked or suspended?
Okay. Well, I know of the, you can't just walk back into AMS and apply for a license. They're going to find you out. They're going to figure it out and who you are. I mean, this is in its own way, it is a tight industry, and people know each other and people know who's who and what's what, and they know who's gone down in the past, so to speak, or been subject to discipline in the past. So that's the one that I'm, aware of. Now, the extent to which and delving deeper into that in terms of, how that plays out and how people might slip through the cracks. I don't know exactly. I've never had a lot of experience with plumbing the depths of that concept as to, somebody claiming, oh, well, I wasn't responsibly connected. And that may be, I'm sure that's a whole issue into itself that you could, get into, which I don't have a whole lot of experience with that in terms of, how it plays out in the field.
Okay. So I guess kind of the answer is, this links to a law or a law firm site.
Yes,
here.
I see that.
So yeah.
Looks like something worth reading. Yeah.
Yeah, that sounds like maybe something fodder for our deep dive.
That's right. Yeah, because that's right. If people want it, we can do a lot deeper dive into this. I had to keep it very basic. So I like the last comment. I want to answer that one.
Okay, so then since the fruit will spoil within 30 days, what good is the trust in a bankruptcy case? Is that what you're saying here? Okay, bankruptcy.
Well, keep in mind, the fruit is not what you're after. The trust is applying to their money. The trust applies to their money, to their assets. It doesn't follow the fruit, so to speak. It follows their assets, whatever they may be. It follows their bank account. So you have a trust against their assets in general. Nobody's expecting somebody to be tracking down, pallets full of, peaches or something. That's why it works, is because it doesn't do that. You're going around all of that. And by the way, last one, the Amishman won his arbitration case after we sorted out the UCC. That was the last one.
Is that what that is? How did your ARB?
Yeah, the ARB case.
ARB case. Yeah, okay, so Amos Miller there.
Yeah.
Mr. Miller.
Yeah. So it was,
Oh,
it
no,
was,
no, that you mentioned before. I'm sorry.
yeah, that was right. It was this arbitration case with the rejected tobacco. But
Gotcha.
I got a quick lesson in, how farmers can get hoodwinked, because this taught me a lot very quickly.
Great. Well, I think that does it. If we don't have any other questions, thank you all for staying with us. Again, that CLE form is in the chat. And Brooke, if you'll advance us. Oh, wait.
Yeah,
no,
there we
I'll
go.
put it up. Doesn't matter because I'll put it
It's
up.
up.
And I think that concludes us for today. Please joining us, a couple weeks there in January for basics of food labeling. And with that, we'll wish you all a belated Happy New Year, and we hope to see you next time. Bye, all.
Okay. Thanks for coming. See ya.